Hi, everybody. Welcome back to the AV to the 7th Power channel, where we talk about all things law, true crime, and a little bit of debauchery. Today, we're diving into the top 10 prosecution fails in the YSL trial. These critical missteps have had a significant impact in the case's trajectory, and we're breaking them down one by one. Let's get into it. And before we dive into our first point, don't forget to like, subscribe, and hit that notification bell so you never miss an update on this trial. Your engagement helps keep this community thriving. Let's start with one of the most talked about prosecution errors: bringing Rico charges. The prosecution made a bold move by bringing Rico charges against the defendants. While Rico is often seen as a powerful tool in dismantling criminal organizations, in this case, it may have been a strategic error. By opting for Rico, the prosecution set a high bar for themselves, requiring them to prove an intricate web of conspiracy. This decision has led to a complex trial with many moving parts and many mistakes, ultimately affecting the case's trajectory in unexpected ways. What do you think about the Rico charges? Was it a good move or did it backfire? Let me know in the comments. Let's move on to the next major fail. 2. Losing control of witnesses. Throughout the trial, there have been multiple instances where prosecution witnesses went off script, did not cooperate, or outright contradicted the prosecution's narrative. This loss of control over witnesses not only weakens their case, but also raises questions about the focus and direction of the trial. Viewer comments that we've posted recently have expressed dissatisfaction with this trial, wasting taxpayer dollars, and often pointing out how some of these testimonies seem to focus on trivial matters rather than the core issues at hand. Is Young Thug guilty of these crimes? Are all of these defendants guilty of the overt acts that they are assigned to in this giant criminal racketeering enterprise that we call YSL? Lack of preparation. This, for me, is probably the biggest one. The prosecutors lack preparation. It has been evident in several key moments. Check out this clip where I watched just one day and got frustrated. This judge told Miss Love yesterday, you guys need to be ready. The DA's office has 200 employees that work for it, over 200 employees. You guys wanted to bring Rico charges. The fact that you are not ready and prepared, we've been talking about this all week, CDA Love. Why is this office not prepared? Why is this office not ready? Why is this office not ready for us to at least chat about this? This is the last business day before the jury comes back. It's 3:50 p.m. on a Thursday, which is technically our Friday. We can't get through jury instructions. You know, she was already kind of irritated at that. But now we find out that even for the witness after, they're not ready. This is an atrocity, guys. And I'm going to go back a few seconds so you can hear how irritated this judge is. She just got assigned to this case from Judge Glanville, who allowed this stuff to happen. But now, and Doug Weinstein said it last week, he said, Judge, this case is like a house with rotting walls. When you start to peel back the layers of the walls, the wallpaper, and you start to see the rot in the wood, the rot in the foundation of the case, the rot holding the house up, you start to see how much problems there have been throughout the entire trial. Let's go back to number one, hear her reaction to the fact that Love, yet again, is not prepared, and what we're going to do to move forward, because we still have an hour to play with here in the courthouse. Let's go back, because you can start to hear the scrambling and scraping. You can start to hear the glitching happening, and it's not okay. So I'm going to go ahead about a minute back and hit play again, but let's listen to this again.
This for Sledge and a list from yesterday. And I'm about to send over another bucket for another witness. So as opposed
Good.
to be able to give all of the exhibits themselves. That's what.
So are you then not just, so I understand, are you providing the actual exhibits?
That's what I had.
Okay. I mean, that's fine. Fine with me. What I want to have happen though is, have you now only done that for Sledge and you're about to do it for one other?
The actual exhibits?
Yeah.
Yeah, because Sledge was the next.
Right. Okay. So what happened to the tranche of the first 30 witnesses?
So that I was working on.
Okay, they were due yesterday.
So that's what I'm trying. That's what I've been working on. Sorry, I can't.
She really hadn't said much.
I haven't said much.
She said, that's what I was working on. And the judge is like, well, I'm done talking to you. Guys, for the record, she really hadn't said much.
Yes,
She was speechless for a minute.
She was speechless for a minute. She was speechless for a minute.
No, yes, I was.
And now she says, that's what I've been working on.
And now she says, that's what I've been working on. The judge with a shade. Let's go, Whitaker.
No.
Okay, so, and maybe you're confused about what it is that I want produced.
Maybe, ma'am, you are confused about what I asked for and what the deadlines were. This is your job. You were supposed to have it done. So now, in the last 5 minutes, we found out that we're not ready with jury instructions. And that, I think, is more on the defense side because there's so many of them. That's a little bit understandable. Everybody's being punished by having to show up early on Monday. But love, you know that we have a problem with little Woody. It's not one thing at a time. This judge is trying to move us along faster. And that means, okay, who are your next 5 witnesses? And since you have all these employees working for you, I would even put like one person on each witness and get everything ready. It's not hard. From failing to anticipate defense arguments to being unorganized in presenting evidence, not being able to answer direct questions from the current judge and previous judge, these lapses have not gone unnoticed. Comments labeling the prosecution as unorganized add to the growing sentiment of unprofessionalism and an inconsideration of local taxpayer dollars. Such a lack of preparation has significantly impacted their credibility in the eyes of both the jury and the public. Preparation is key in any trial, right? Drop a thumbs up if you agree that being organized could have changed the course of this trial. 4. Brady violation accusations. Brady violations are serious accusations that can have dire consequences for a case. In this trial, claims of the prosecution withholding evidence from the defense have surfaced, undermining their credibility not just once, many times, to the point where the new judge, Judge Whitaker, is requiring the prosecution team to take Brady evidence training. This DA's office, led by one Fonnie Willis, took a slap in the face when this judge required its prosecutors to learn about the Brady rule.
Everybody ready? Listen to this.
Before you step to the door, is there at this stage, which is mid-trial, anything else, whether Brady or not, that you think might be relevant to either the state or the defense in trying this case that you, the state, know of that the defense still does not know of?
All right, that's the question. Everybody, let's listen to the answer. Go.
And you may want to.
That's the answer, guys. That's the answer. That's the It's a wrap. This case is a fucking wrap. And I love this judge. I love the judge, but I hate the fact the judge let her off the fucking hook.
High-profile cases affected by Brady violations, such as the Duke lacrosse case, remind us of the significant impact these accusations can have on a trial's outcome. If proven, these violations could lead to severe repercussions for the prosecution, leading to ultimate disqualification of the prosecution team. 5. Witness intimidation. Allegations of witness intimidation have surfaced in this case, casting a shadow over the fairness and ethical standards of the trial. There were multiple accusations of witness intimidation and coercion from the prosecution side. This was especially highlighted in the testimony of key witnesses like Little Woody, Mr. Kenneth Copeland. The credibility of these claims is crucial, as they resonate with public concerns about the integrity of the prosecution's approach. If true, such intimidation could not only tarnish the prosecution's reputation, but also lead to further challenges down the line. Recently, in some of the court proceedings we've seen, just as early as this week, we see that the judge not only did not agree with the nature of the meeting, but also agreed that the prosecution did not fully and adequately explain to Little Woody what his rights were. Witness intimidation is a serious allegation. What do you think about the credibility of these claims? Let's discuss in the comments. 6. Failure to provide full discovery. The prosecution's failure to provide full discovery has led to delays and public mistrust, and we've seen the level of being unprepared. But with a complex case like this one, it is crucial that handling full discovery requests to the large defense team is important. This could hamper the defense's ability to prepare adequately. By creating a habit of not sharing crucial evidence with the defense, the prosecution has created an environment of suspicion and frustration. These delays have not only added to the growing sense of public dissatisfaction with how the case is being handled, but it further damages the prosecution's standing. Delays are frustrating, especially in a trial this big. How do you feel about the prosecution's handling of discovery? Let me know below. 7. Inconsistent testimony management. One of the biggest things that makes this trial an absolute dumpster fire is the inconsistent testimony management tasked with the prosecution team that has been another major issue for the prosecution. There have been several moments where witness testimonies have conflicted, casted doubt on the reliability of the prosecution's case. Handling of testimonies such as that of Kenneth Copeland, who initially refused to testify, then changed his stance, leading to significant disruption in court proceedings and delays on delays on delays.
Apart from the criminal charges that you helped resolve in 2023, you recall saying to a member of the district attorney's office, "I'm representing Kenneth Copeland as a witness only in the YSL trial."
I said that to you, okay?
That is your memory.
Yes.
Where was this? Was it on the phone?
Yes.
Okay. And what was it? Was it before or after Mr. Copeland resolved his criminal charges?
I guess before, because it was when we were talking about the bond issue.
And so what exactly did you say about your representation?
I said that I was representing him, and if you want to talk to him, talk to me.
Again, boom!
When you said you were representing him, isn't it true that you were talking about those criminal charges?
No, Miss Love, it's not true.
Did you state that you were representing him beyond those criminal charges?
Had you finished your answer?
That's fine, yes.
Make sure he finishes his answer before you put the next one on the floor, okay?
Did you state that you were representing Kenneth Copeland in his capacity as a witness in the 22 SC 183572 case?
Yes.
Outside of the criminal charges?
Yes.
And did I hear you say that it was your testimony that you never once indicated that Kenneth Copeland had not paid you and you weren't even representing him?
Irrelevant.
No.
So is it also your testimony that no one from the DA's office reached out to you to try and get you to go speak with Mr. Copeland
About what?
about his criminal charges.
Nobody tried to reach me to go talk to Mr. Copeland about his criminal charges.
Is that your testimony?
I don't know why that would be necessary.
That wasn't the question. Answer the question.
No, I don't recall anybody speaking to me about going to talk to Mr. Copeland about his criminal charges.
And so is it fair to say you also don't remember telling any member of the DA's office that you were on vacation and you were not able to deal with Mr. Copeland's criminal charge?
So I resolved Mr. Copeland's criminal charges. As far as I know, I resolved them to Mr. Copeland's satisfaction. And it may well be that at some point I was on vacation and not available to go speak to Mr. Copeland. I don't recall specific dates and times, but there is no issue with communication between myself and Mr. Copeland. Okay.
So as it relates to the question that I asked, do you recall there being a time when you conveyed to the district attorney's office that you were on vacation and could not go to talk with Mr. Copeland?
Ms. Love, if you have such a communication, then I'm sure it exists. The fact that I may have been on vacation a day or a week doesn't mean that I wasn't communicating with my client.
He's
Okay.
cooking her.
And if you would mind answering whether or not you recall.
I don't recall.
All right, y'all, we've been at this for over an hour and it's really not particularly relevant anyway. So let's wrap things up.
Yes, you have.
These inconsistencies have left viewers skeptical, questioning whether the prosecution has a solid grasp of facts or if they are just grasping at straws. Inconsistent testimonies can make or break a case. What do you think? Are these just honest mistakes or something more? 8. Judge recusal issues. The circumstances leading to judge recusals have further complicated the trial. Judge recusals can disrupt the continuity of a case, leading to delays and potentially even mistrials. We saw Judge Glanville recuse. We saw Judge Ingram recuse. The frequent recusal of judges, including Judge Ingram, due to an ex-deputy's misconduct, added more confusion and instability to the trial proceedings. These issues contribute to the perception of judicial bias or mismanagement, all from the same courthouse, which only adds to the public's frustration with how the trial is being conducted. Judge recusal can change the entire dynamic of a trial. Do you think this is necessary, or just more chaos in an already messy case? Check out the sponsor of today's video, Aura. Speaking of chaos, the digital world can be chaotic sometimes. Stop robocalls today. Secure your online data with a free 14-day subscription using my code below. Let's get back into it. 9. Delays to mismanagement. Mismanagement by the prosecution has led to numerous delays throughout the trial, frustrating everyone involved. From the defendants to the public, numerous delays and interruptions due to the prosecution's handling of witnesses and evidence affecting the trial's timeline and overall efficiency. These delays have often been due to organizational issues, management issues, delegation, or last-minute changes in strategy, which have only served to prolong the trial unnecessarily, with defendants remaining incarcerated and their rights violated. Viewer comments frequently mention their annoyance with how drawn out the process has become, much of which is attributed to prosecutorial mismanagement. Long delays can make a trial unbearable. Last but not least, ex parte communications have been a hot topic in this trial. These illegal and highly controversial communications between the judge and prosecution have severely impacted the fairness of this trial. The controversy over the Glanville prosecution ex parte communication between Judge Glanville, prosecutors, state witnesses, which was flagged by Young Thug's attorney Brian Steele, has led to a successful motion for recusal of Judge Glanville.
Just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you.
What?
And then somehow that email was CC'd to me. That never.
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me and you and Mr. Adams meet with me and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said.
And you haven't answered my question yet.
How did you answer that question?
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to.
No. I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based on information.
You got this information, then you and I are going to have some problems.
We can have I have problems right now.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, wow. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a witness who was sworn in Friday. The court's telling. This is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that, but I'm going to.
Well, do y'all see the conflict? The judge wants the name.
Right.
The judge says, tell me the name. Who told you? We can talk about anything you want afterwards, but tell me the name. Brian Steele says, I'm not going to tell you the name. Right. So this is the major conflict going on right now. Let's go.
Say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
Information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court.
Okay.
Or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is.
Oh my God. So he has actual word for word. He has actual word for word testimony of what was said in these secret meetings.
Wow.
Let's go.
He announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court.
Okay.
Or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
sir? I'm going to hold you in contempt if you don't tell me who. Tell me who this information was.
I don't want to be held in contempt. Well, I'm not answering that question. That's attorney-client privilege information. I am not.
Attorney-client privilege, unless you were in my chambers, that's the only way you can figure out.
I am
I
telling
tell you what, I'm going to give you 5 minutes. If you don't tell me,
You don't have to.
If you don't tell me who it is, I'm going to put you.
Well, let me-
I'm going to put you in contempt
I
because
understand.
that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information
I don't
supposedly
answer.
from my chambers?
Hmm.
Did somebody tell you?
I'm not. You should have told me.
Oh,
You got 5 minutes. Well, yeah.
Oh my God.
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was, don't take my notes. No.
what?
Ex parte communications are a big no-no in any trial. How do you think this will affect the outcome? As we can see, these prosecution fails have significantly impacted the YSL trial. From strategic missteps like the Rico charges to severe allegations like Brady violations and witness intimidation, each of these issues has contributed to the trial's increasingly complex and controversial nature. These errors by the prosecution not only shape the outcome of this trial, but also highlight the importance of proper legal conduct and preparation in high-stake cases. The public's trust in the justice system is on the line, and every misstep adds to the growing skepticism. Thanks for watching. If you found this breakdown insightful, be sure to hit the like button, share your thoughts in the comments, and subscribe to stay updated on all things YSL. See you in the next video. Stay safe out there. Bye.